Marital property is property that is acquired during marriage. So it can be either purchased or acquired as a gift during marriage. When you get a marital property question, you're going to want to distinguish between whether or not you are in a separate property system or a community property system. Most states have a separate property system, but 9 states in the U.S. have a community property system, and those 9 states are rather, 2 of those 9 states are rather large, California and Texas. So marital property rights under a modern property system, a separate property system or a community property system, can be divided into 3 categories. There are property rights acquired during marriage, property rights acquired at divorce, and property rights acquired at death. For both separate and community property systems, any property that is acquired before marriage is non-marital property, and each individual party would own, that is their own property, right? So if a husband and his partner, his wife, let's say, they get married, it's at that point that we start to record what the marital property is. Any property acquired before the point of marriage is considered separate property, their own property. And it's separate property, it's even considered separate property in a community property state. All right, so anything acquired before marriage is each person's separate property. During marriage, for a separate property system, the basic rule is that property is separately owned by the spouse that acquires it. So just like before the marriage, how each party owned the property that they acquired, that same rule goes on through the marriage. So in a separate property system, before and after marriage can be very similar, right? So it's separate property. So let's talk in examples. Let's say a husband owned $500,000 in stocks and bonds, and then he got married to his partner. He would continue to own that property after the marriage, that $500,000. All right, that's considered separate property. Let's say his partner owned $300,000 worth of property before the marriage. That $300,000 is their own property as well. Okay, so now during the marriage, the husband is a lawyer and he makes a lot of money. He buys cars with that money. He buys a house with that money. Well, in a separate property state, the house, the car, all that's purchased by the husband is owned by the husband, even if that is purchased and acquired during marriage. Now, under this type of separate property system, any debt that's incurred by the husband can only reach the husband's property. And any debt incurred by his partner spouse can only be reached by the creditors of the partner spouse. In other words, a husband's creditors cannot go after his partner spouse's assets to satisfy a judgment against the husband. Now, in a separate property state, the spouses can decide that they want to hold property as joint tenants or even as a tenancy by entirety. But if they don't make that decision and include that explicit language, then it defaults to separate property. Now let's compare that to a community property state. In a community property state, all property acquired during the marriage is owned by both spouses equally. So the idea in a community property state is that each spouse contributes equally to the marriage, and while that may not look the same, while one spouse may be taking care of the kids and holding a part-time job, and the other spouse might have a high-powered job where they make a lot of money and they're the primary income winner in that couple, they each contribute to the marriage. And so in a community property state, all earnings that are acquired during the marriage and all property that is purchased out of those earnings are considered community property. But anything that was brought into the marriage, anything that was purchased before the marriage, anything that was earned before the marriage is still separate property. So let's go over that again. Before marriage, in both a separate and a community property state, whatever a spouse or a person has acquired is their own separate property. Once they get married, jurisdictions differ on how they characterize the ownership of the property that is acquired during marriage. In a separate property state, they would trace to see who earned the money, who used that money to then purchase whatever the asset is or property. That person would own that property. So each person separately owns their own property based on the income they generate and what they purchase with that income. Also, in a separate property state, creditors can only go after the property of that person who incurred the debt. They can't go after the spouse. In a community property state, this is different. So although in a community property state, just like in a separate property state, whatever property is brought into the marriage or acquired before the marriage is separate property. Once the marriage starts, property that is acquired during the marriage is considered to be jointly owned equally by both spouses, regardless of who generates the money. Now, because each holds an equal and undivided share in the community property, they also cannot transfer the property without the consent of the other spouse. So it prevents one spouse from transferring what is community property to another party. Both spouses have to agree. You might say, well, this sounds like some type of tenancy or tenancy by entirety, but the difference is that in community property state, neither spouse has the right of survivorship. So what happens is that, let's say you have $100,000 of community property. Spouse A and B have in community properties $100,000. Spouse B dies. So now spouse B can devise 50% of the community assets to whomever they would like. So there's no right of survivorship here. All right, it's not like when spouse A passes away or spouse B passes away, all of spouse B's property goes to spouse A. No, spouse B is able to, they own 50%, and therefore they are able to devise 50%. And they can also, of course, devise any property that was separate property that they had before the marriage. Let's talk about divorce. Most separate property states, they mandate something called equitable distribution of a property. And that gives the court discretion in dividing the assets and dividing the property in a just and fair manner. So courts make a factual determination based on the spouse's income, any special needs they might have, the length of the marriage. Now, in these separate property states, that can, depending on the state, that division, what's considered just and equal, could be 50%. So you might end up getting the same outcome. But it is a factual determination made by the court. In a community property state, at divorce, all community property is divided equally between the spouses. All right, let's talk about death. At death in a separate property state, to make up for the inequality that can result if one spouse has most of the assets titled in their name and they die, they have enacted what is called a forced share or an elective share that mandates that at least a percentage of the share of the deceased spouse share goes to the surviving spouse. Now, I'm not going to worry about testing this in this property class. I did want to explain it briefly. It is something that we cover in great depth in wills and trusts. At death in a community property state, like I said before, the decedent can devise half of their community property, half of the community property, and all of their separate property. So there isn't a right of survivorship. That's the main thing you need to know for the purposes of this class. Later on, when you get into wills and trusts, you can go in more depth into what happens at death and how that differs depending on the states. So where does a tenancy by entirety fit in? Well, today only half of states require tenancies by entireties. And they are beneficial because they do offer significant protections from creditors. Tenancy by entirety are useful and can be used in states that have separate property systems because the spouses can override the default separate property designation by putting the property in a tenancy by entirety. If they decide to title a property as a tenancy by entirety or to take property as tenancy by entirety, then they have a right of survivorship and it protects from creditors. What happens if that use, though, is used to defraud creditors, right? So let's say that a spouse negligently injures two pedestrians while driving their car. And the pedestrians sue under a personal injury action. Say the house of the spouse is the only asset that both he and his partner spouse have. Let's say they own it as tenants by entirety. Well, they decide that the case might not be going their way, and they want to protect their house. So they convey their home shortly before the judgment is entered in the case to their son as a gift. Is this a fraudulent conveyance? One that's made for the purposes of avoiding a judgment? If it is, then the creditors would be able to set it aside. Let's explore that question in Sawada v. Indo. Sawada v. Indo is a case from the Supreme Court of Hawaii, and the facts are very similar to the hypothetical that I just gave you. And the question before the court was whether the interest of one spouse in real property that's held in tenancy by entireties is subject to the levy and execution by his or her individual creditors. And before this case, Hawaii had not decided or didn't have case law on this. This is a case of first impression, meaning the court has to look at public policy or other jurisdictions and try to decide how they believe that the court should rule on this particular question. Whether the creditor of one spouse could reach property held by tenancy by entireties. The court goes over 4 approaches. What are these 4 approaches? I'd like you to summarize the difference between each of these 4 approaches. All right, so the group 1 of states that, which is the first, represents the first approach, they still have the common law tenancy by entireties, and at least at the printing of this case. And at common law, the possessions and profits for the estates are subject to the husband's exclusive dominion and control. Women did not have property or control over their property. So that, they said, was approach 1. For approach 2, they said that some states allow for the interest of the debtor spouse to be sold or put up as collateral for his or her separate debts, but that this was subject to the other spouse's contingent right of ownership. The third approach are states that find that if there is a tenancy by entirety, any attempted conveyance by either spouse of the tenancy, of their share of the tenancy by entirety, is considered void. And because it is considered void, that means that similarly that their half cannot be subjected to separate debts, so the debts that are incurred by only one of the spouses. The fourth approach gives a separately alienable ownership right that can be attached by creditors to each of the spouses. But they find that the use and profits could not be alienated or attached. Now, for our purposes, if you get a question about tenancy by entirety and whether or not a separate creditor can attach, you just kind of generally want to know that some states allow for attachment and other states don't. And that would be sufficient for any essay question that we would have. So my next question is, which approach did the court decide to go with and why? Well, the court held that the interest of a husband or a wife in an estate by the entireties or a tenancy by entireties is not subject to the claims of his or her individual creditors during the joint lives of the spouses. You'd find that on page 408, third paragraph. The reasoning for their decision, the court cites in the third paragraph on page 509, that neither the husband or the wife has a separate divisible interest in the property. So because they don't have a separate divisible interest, and that indivisibility of the estate is a key tenet or a key feature of the joint tenancy, then only joint action by both spouses could convey the property or could make it so that the property is reached by a creditor. What did the dissent argue? So the dissent argued that essentially a wife takes equal rights with the husband in the estate, and so she must take equal disabilities. That's on page 411. A wife takes equal rights with the husband in the estate, and therefore she must take equal disabilities. What does that mean? Well, she is enjoying, the argument is that she is enjoying the benefits of the property, and as such, she should be subject to the debts of that property. What do you think about the outcome of this case? Shouldn't the guilty endo be compelled to make the innocent Swadas whole? And why should the law allow endo to convey his home for the purpose of defeating the judgment? And I'd also like you to consider this. Endo and his wife received extra protection from creditors just because they were married. What justifies that? Should married couples receive extra protection from creditors? Forgot to move the slide forward. So should married couples receive extra protections from creditors? Well, The arguments that are made to support this extra protection is that um, married couples, unlike business partners, they have a long-term, theoretically, a long-term commitment to one another. You have one spouse that may be relying on the other spouse more than others. But that justification doesn't address why only married spouses get that as opposed to long-term domestic partners or other types of long-term committed relationships that are actually growing more and more common in the United States and have become more of the norm. So it doesn't quite address that. Well, what about the tort victims? Should tort victims receive more protections than voluntary creditors? Because tort victims didn't ask for it, right? They didn't enter into a negotiation. They didn't decide to take a risk like a credit card company did or a home mortgager did, right? They don't decide to take a business risk on somebody. They don't have whole teams of people calculating risk. Should tort victims receive different treatment than voluntary creditors? Arguments have definitely been made to that effect, that tort victims should receive additional protections. There was a famous case we go over in the Wills and Trust class that I teach, where we talk about somebody committed a heinous crime, was sued in civil court, but had transferred all of his assets into a trust. And although he was found criminally and civilly liable, there were no assets to try to at least make up for what this person had done. Just wanted to briefly touch on same-sex marriage as it applies to and why it's important in relation to property specifically. So I didn't assign the Obergefell v. Hodges case. It is a good one if you haven't read it. I didn't assign it because I don't want to get into discussions of constitutional arguments and so forth. I just wanted to explain why having the right to marry was important in the property context. So you could imagine in a community property state, after same-sex marriage was recognized as a legal marriage, then whether they wanted it or not, same-sex couples were subject to community property rules, and were also subject to, on death in separate property states, forced share elections. They can now also hold property as tenancy in entirety, right? So there were some, the ruling had great practical effects on the way property is held or the way that property is treated at separation. So just want to highlight that. And that concludes Monday's video lectures.